Welcome back to the RG Limited boardroom. Adjust your lighting and pour yourself a glass of something so rare it doesn't even have a label, because we're closing the book on the CITCC and BTEM saga with the ultimate cautionary tale: how to lose a United States 6.2 million victory because you forgot to bring your permission slip to the courtroom. We are looking at the 2025 final strike from the Court of Appeal in the battle between China International Telecommunication Construction Corporation (CITCC) and BTAM Communications. If you think a trial court win is a guarantee of wealth, this case will remind you that in the high stakes world of infrastructure, procedure is the only god we worship. The scene: the $6 million dream. This started with a 1998 agency agreement to build a national optical fiber backbone network. BTAM claimed they were the instrumental, quote, focal person who made the deal happen. And they wanted their 3.75% cut, a staggering United States dollars 6,225,000. They actually won in the High Court, walked away with a massive award, and probably started picking out their Ferraris. The scandal, the invisible plaintiff. But when the case reached the Court of Appeal, CITCC played the most ruthless card in the boardroom: locus standi. They argued that BTAM Tanzania did not even have the right to be in the room. Why? Because the original contract was with a company in the British Virgin Islands. The BTAM Tanzania was just an agent that hadn't followed the rules of engagement. The boardroom reality check. Permission is power. In this boardroom, we know that a company is an autonomous legal beast. You don't just wake up and sue for $6 million. You need a board resolution. The missing resolution: BTAM couldn't produce a formal resolution from the parent company's board of directors authorizing the suit. The power of attorney fail. They tried to use a power of attorney donated in China, but it was dead on arrival. Why? Because they forgot to register it locally in Tanzania. In our world, darling, if the paperwork isn't registered, it's just a very expensive piece of scrap paper. The privity hammer. The Court of Appeal dropped a truth bomb that every, quote, top of the pyramid executive needs to memorize: the doctrine of privity of contract. Only the parties who actually signed the deal have the right to enforce it. BTAM Tanzania was an agent, but they made the fatal error of suing in their own name instead of on behalf of their principal. The court called the suit, quote, frivolous and untenable, and the trial court's decision, quote, inconsequential. They struck the whole thing out. The Oksana Ryabets final takeaway. Darlings, BTAM spent 12 years chasing this commission only to have the highest court in the land tell them their claim was, quote, superfluous from the beginning. Board resolutions are non-negotiable. If your company is suing, the first document in the file must be a formal board resolution. Without it, the suit is, quote, defective and, quote, incompetent. Check your signature. If you are an agent, you sue in the principal's name. Don't let your ego get in the way of your standing. Suing in your own name when you aren't privy to the contract is a one-way ticket to dismissal. Local registration is key. Any authority donated abroad, like a power of attorney, must be registered locally under the Documents Registration Act, or it holds zero weight in a Tanzanian court. Beatam won the battle in the High Court, but they lost the war and the $6 million because they fumbled the most basic procedural play. In the RG Limited boardroom, we don't just win, we make sure we have the legal capacity to keep the prize. Now, if you'll excuse me, I need to go ensure all my local registrations are up to date. I have no interest in my victories being called inconsequential.